It's usually quite difficult to overturn a prenuptial agreement in Texas, but one of the ways that you can overturn it is to show that there was a lack of full disclosure and there was hiding of assets before the prenuptial agreement was signed by the parties. My name's Lisa. I'm a Texas divorce attorney who's been helping my clients with prenuptial agreements all over the state of Texas for over 10 years. Before signing a prenuptial agreement, Texas law requires that each person gives their fiancé a fair and reasonable description of the assets and debts that they have before starting the marriage. Fair and reasonable disclosure does not necessarily mean that it needs to be completely accurate. Sometimes certain assets, like stocks or checking accounts, can fluctuate on a day-to-day basis. Since Texas law only requires a fair and reasonable disclosure of your assets, that means that you can still be a bit off and it'll still qualify as a disclosure so as not to overturn your prenuptial agreement. But if a court finds that you made a major omission in the disclosure of your assets, that could spell trouble for the enforcement of your prenuptial agreement. A court can overturn a prenuptial agreement if they find that one spouse was hiding assets and didn't disclose the assets and the other spouse had no way to know about them before signing the prenuptial agreement. If that's the case, that could mean that your property is going to be divided in a way that you did not anticipate in that prenuptial agreement. One of the questions my clients ask me is, what if I accidentally forget about an asset and I don't disclose in my prenuptial agreement? I always encourage my clients to make a full disclosure of their assets and debts. It's not only the basis of a good prenuptial agreement, truth is a good basis for a marriage in general.